She was already halfway across my lawn when she saw me watching. She didn't stop. I went outside. She had parked, stepped out, and was walking toward her front door by the time I reached the steps. I called across, "Margaret, that's private property you just drove across." She stopped. She turned, adjusted the lanyard HOA board president block letters on laminated plastic like a credential before correcting someone beneath her. "This corner has always been a natural pass-through," she said. "I've been using it for 3 years. It is not a problem. And if you're planning to make it one, I'll bring it before the full board." A small pause. "You won't enjoy that conversation." She went inside. I stood in the tire tracks she'd just made and thought she has no idea what's sitting on my kitchen table. The morning was still quiet, cul-de-sac empty, no one else out yet. I looked down at the corner of my lawn. Fresh tread marks, pressed into older ones still. 7 distinct sets, just from this week. 7 crossings in 5 days. That corner had stopped looking like grass sometime around month 4. Now it looked like a cut-through, a path someone had decided to build through my yard without bothering to mention it. She had been using this route for 3 years. She would use it for exactly 3 more weeks. I had been photographing this corner since month 2. 23 documented incidents, each one time-stamped. Each one framed to include the property line markers in the background, backed up on 2 separate drives. A printed folder in my desk with every incident logged by date. In the beginning, I did it out of habit, the kind of documentation you start before you're sure what you'll need it for. By month 6, I knew exactly what I was building. I also had the deed to this property in a cardboard tube on my kitchen table. I pulled it out the previous week, after spending an evening reading the full 22 pages of the HOA bylaws front to back, looking for any language explicit or ambiguous that might give a board member vehicle access across a private residential lot. I found none, not one clause. The HOA had authority over cosmetic standards, shared amenities, and noise enforcement. That was where its authority ended. It ended at my property line. My property line was where the deed and the county plat said it was, and it had never moved. Margaret had never asked to see the deed. It hadn't seemed to occur to her that a document like that could matter to her situation. Natural pass-through. I kept turning that phrase over as I stood there. It sounds official, like a legal designation, a historical status, something everyone else already knows about, and you're just the last to be briefed on. Margaret had been running that kind of language on this neighborhood for years. Say it with authority, adjust the badge, let the other person feel the weight of institutional confidence pressing down, until they back off before they think to ask for the actual document. Most people stopped asking when she did that. I had watched it work on the Hendersons 2 doors down, the family across the cul-de-sac, the retired couple in the corner house. Each of them had received a notice, paid a fine, and decided it was easier to comply than to find out where the real line was. Margaret understood that about people. Her entire operation was built on it. I wasn't going to stop asking. I went back inside and unrolled the county plat map across the kitchen table next to the deed, found the corner section, traced the property lines. My boundary ran exactly where I already knew it did, straight through the center of the strip she'd been crossing for 18 months. No easement notation on file with the county. No shared use language, no right-of-way recorded in any form, nothing that gave any person board title or otherwise the legal right to drive a vehicle across that ground. There had never been a natural pass-through on this corner, not legally, not once, not in any document this county had ever recorded. I rolled the plat back up, put it in the tube with the deed, and set both on the shelf above the desk where they'd be easy to find. I poured the cold coffee down the drain and made a fresh cup. Through the window, the tire tracks were still dark against the morning grass. 3 years of someone else's unverified certainty pressed right into the corner of my lawn. She had gone inside feeling like the conversation was finished. It wasn't finished. It had just become useful. I didn't go back to the window angry. Anger makes you loud, and loud people lose. I went back patient, and in this particular situation, patient was a considerably more dangerous thing to be. She had the badge, she had the board, she had 3 years of unchallenged habit working in her favor. I had the plat map, and I was already starting to think about what to do with the ground beneath those tire tracks. I bought this house 6 years ago. Margaret Chen became HOA board president 4 years ago. The first year under her was quiet. A few new notices posted on the community board, updated parking guidelines, revised holiday decoration schedules, a reminder about approved paint colors for front shutters. Annoying in the way those things always are. Nothing worth raising my voice about.
Then the letters started arriving.
Not HOA newsletters. Fine notices. Personally addressed, printed on HOA letterhead, citing the HOA Community Standards Code, with a section number and a dollar amount. The first one went to the Hendersons, 2 doors down. $85 for trash bins visible from the street on garbage collection morning. Not after garbage day, on garbage day. The bins were out because it was the day you put the bins out. The Hendersons paid it. I watched through the window as the check went into their mailbox. I remember thinking, that's going to happen again. It did. To them. To the family across the cul-de-sac, $120 for a car parked approximately 2 inches past the driveway edge, measured according to the notice from the painted curb line. To the retired couple in the corner house, $200 for holiday lights, still up on January 7th. The code specified January 6th. 1 day. $200. I pulled the HOA Community Standards Code from the welcome packet I'd been given when I moved in and read it start to finish. Then I read the original HOA bylaws, which were a separate document that predated Karen's board. Then I compared them side by side. The code Karen was fining people against wasn't the bylaws. It was a supplemental standards document, one she had updated and redistributed on her own authority as board president without putting the changes to a full membership vote. Some of the sections she was citing in her fine notices didn't exist in the original document at all. She had written new rules and started enforcing them as if they'd always been there. I put both documents in a folder and labeled it. I didn't say anything yet. I was still reading. The lawn shortcut started 18 months ago. A privacy fence went up on Carver Court, 2 streets over, cutting off a route that a handful of residents had informally used to cut through to the main road. It rerouted traffic into the cul-de-sac. Most people adjusted. They took the slightly longer loop around on the paved road, the way it was always supposed to work. Margaret took a different approach. The first time her SUV cut across the corner of my lawn, I assumed it was an error in judgment. A wide turn, a moment of inattention. I noted it and moved on. The second time I watched from the window, she didn't cut wide. She turned deliberately. That corner was a shortcut and she had decided apparently that it was hers to use. The third time I went outside and walked over to where she was parking. I said evenly that I'd noticed her vehicle coming across my property and I'd appreciate it if she used the road. She listened to me finish, nodded once and said, "The HOA governs shared aesthetics and community safety. The path isn't harming anything. I'll keep that in mind." Then she went inside. 3 days later, a fine notice arrived at my door. $75. Reason, non-regulation mailbox post height exceeds maximum 42-inch standard per HOA, Community Standards Code Section 4.2b. I had owned that mailbox for 6 years. The post had been the same height for 6 years. Not one word about it until 72 hours after I raised the issue of her driving across my property. I measured the post. It was 43 inches. 1 inch over a standard she had written into a supplemental document without a membership vote. I paid the fine. I photographed the fine notice, checked the mailbox, and the measuring tape showing 43 inches, and I added them all to the folder. Then I started a second folder, specifically for Margaret's vehicle crossings, and I began photographing those too. Date, time, angle, showing property line markers. Over the next few weeks, I started paying quiet attention to the broader pattern. 96 homes in this HOA. I counted at least 11 that had received formal fine notices in the past calendar year. 3 of those families had received multiple notices, the kind that, if left to compound, could theoretically support a lien against the property. In real terms, that meant Margaret's fine machine had the theoretical ability to make a family's mortgage situation more complicated. Not easily, not quickly, but the mechanism was there, and she knew it, and the families receiving the notices knew it. Nobody was pushing back. I understood why. A lien notice is a frightening piece of paper, whether or not it's legally supported. Most people see the letterhead and the dollar amount, and they pay and they move on, because fighting feels expensive and uncertain, and the fine is cheaper than finding out where the real line is. Margaret understood that too. The whole system ran on it. She controlled the board. The board controlled the fine process. The fine process controlled 96 households through the straightforward application of financial anxiety. It was not complicated. It didn't need to be complicated. It just needed people to keep assuming she had more authority than she actually did. I pulled the HOA bylaws out again that evening, the original ones, and read through them a second time, looking for anything that authorized vehicle access across private residential lots. 22 pages. I read every clause. Nothing. Not even a stretch. No language that gave any board member in any capacity permission to drive across a private homeowner's property. The HOA's authority ended at my property line. The deed and the county plat said where that line was. I closed the folder, put the bylaws on top, and set it on the desk next to the tube with the deed and the plat map. This wasn't about the lawn. It never was. It was about whether the rules applied to everyone, or only to people who hadn't read them closely enough to know which ones were real. I had been reasonable. I had tried verbal. It hadn't worked. So I sat down at my desk and wrote Margaret Chen a formal letter. Not an email. A printed letter signed with a pen, sent via certified mail with a return receipt card. I listed 8 specific incidents. Dates, times, a description of the tire tracks visible in photographs, the county plot number for the exact corner she had been crossing, and I stated plainly that continued vehicle access across my land without written permission constitutes civil trespass under state law. I kept the tone factual and direct. No anger in the language. No ultimatums. I was not threatening anything. I was documenting a position and stating on paper that I was aware of my rights. There is a significant difference between threatening someone and informing them of the law, and that difference was going to matter later. I sent the letter on a Tuesday morning. The certified mail confirmation card came back 4 days later. Her response arrived the same afternoon. Not a phone call, not a letter, not an apology. A fine notice. $150. Reason: obstructing community access flow in violation of HOA Community Standards Code Section 7.1a. I pulled out my copy of the HOA Community Standards Code and looked up Section 7.1a. There was a Section 7.1 general maintenance language relating to shared common area pathways. There was no subsection A. There was no mention of community access flow anywhere in the document. No county statute cited. No recorded easement referenced. No legal mechanism of any kind that connected her signature to my property. Just a section number that didn't exist, and Margaret's name at the bottom. She had responded to a formal trespass notice by fabricating a citation. That wasn't an accident. That was someone who expected the paper itself to be enough. Expected me to look at the dollar amount and the official-looking letterhead and fold the same way 11 other households had folded. She had done this before. It had worked before. I filed the notice in the folder and photographed it front and back. Then I called a licensed property surveyor and commissioned a certified boundary survey of my full property exact coordinates, stamped and signed, legally recordable. The cost was several $100s. Some expenses are investments. This was one. While I waited for the survey appointment, I spent an evening researching the one legal mechanism that could theoretically have given Karen any footing: prescriptive easement. The idea is simple. If someone uses another person's land openly and continuously for long enough, a court can recognize it as a legal right. The required period in this state was 15 years of uninterrupted documented use. Karen had been cutting across my corner for 18 months. She was not close. She wasn't in the same time zone as close. I noted that in the folder, closed the laptop, and went to bed. 3 days after the survey appointment, I walked out to the community mailbox cluster at the end of the street. Margaret was already there. I don't know whether she had been watching from her window or whether the timing was coincidence. It didn't matter either way. She had clearly been thinking about what to say because she started before I'd finished with my stack of mail. "I want to be direct with you," she said. The same tone she used at board meetings. Calm, almost pleasant. The particular register of someone who is about to cost you something. The certified mail approach isn't going to go the way you're hoping. I have the full board behind me. If you keep pushing this, I will make your property the most cited address in this HOA's history. A brief pause then. I have that authority, and I will use it. She smiled at the end of it. The particular smile of someone who has delivered that line before and watched it land. I finished sorting my mail. Junk, a bill, a survey company acknowledgement. I tucked the stack under my arm and looked at her directly. "Can you show me," I said, "in writing, which specific section of the HOA bylaws grants you or any board member vehicle access across a privately owned residential lot?" The smile held for exactly 2 seconds. Then it tightened at the corners. She kept her eyes on me. But the answer didn't come. There was no clause, and she knew there was no clause, and for the first time in this entire exchange, we both knew that I knew it too. Whatever this had been until now, a performance, a power display, a test of whether I would fold like the others, it had just changed shape. "You know exactly what you're doing," she said. "I'm asking a question," I said. She turned and walked back toward her house without another word. I watched her go, then walked home the other direction. That evening, I made a 30-minute call to a real estate attorney. He confirmed what I had been reading. An HOA board holds no authority over private residential lot access. The only mechanism that could have created Karen's claimed right was prescriptive easement, 15 years of documented continuous use under state statute. She had 18 months. I thanked him and ended the call. Then I sat with the folders spread across the kitchen table, certified mail confirmation, fabricated fine notice, attorney notes, survey appointment acknowledgement, and went through each one in order. Karen had the board, she had the fine machine, she had the smile. I had the documents, I had the receipts, and in a matter of weeks, I would have one more thing. 2 weeks later, the certified survey came back. The corner she had been driving across for 18 months. Every inch of it was mine. Exact coordinates stamped and signed by a licensed surveyor, county recorded. No easement of any kind reflected in the filing. No shared use notation, nothing. I had the coordinates. I had the document, and I had just started thinking about what to do with the ground. The certified survey arrived on a Thursday morning in a flat cardboard envelope. I opened it at the kitchen table, unfolded the document, and read through it once. Then I set it down and looked at it for a moment, the way you look at something you already knew was coming, but still needed to see in print. Every inch of the corner Margaret Chen had been driving across for 18 months was mine. Exact coordinates, property boundary markers, plotted to the foot, county stamp in blue ink, licensed surveyor's signature in the bottom right corner. The property line ran exactly where I had always said it ran, and in the recorded easement field, the section that would have listed any historical right-of-way, any shared use agreement, any legal recognition of a natural pass-through, there was nothing. A blank line, because there was nothing to record. The document was official stamped and legally recordable. It was also, I realized, the single most important piece of paper in this entire situation. Everything else I had built, the photo log, the fine notices, the attorney notes, the certified mail confirmation, was supporting material. This was the foundation. This was the thing she could not argue with, because it came from the county, and it didn't have her name on it. I put it in a document sleeve, labeled it, and set it at the front of the folder. The main weapon, ready to be used when the moment was right. But I wasn't ready to use it yet. First, I needed to understand the full scope of what I was actually dealing with. Over the next 2 evenings, I walked the cul-de-sac, not with a clipboard, not with a petition. I just knocked on the doors of people I already knew and said I wanted to talk for a few minutes. I had been living here long enough that the conversation started easily. What I heard over those 2 evenings was worse than my own situation, not because the individual incidents were more dramatic, but because the pattern was so consistent across so many households that it stopped looking like a series of disputes and started looking like a system. The Hendersons were first. Retired couple 2 doors down, the ones I had watched mail a check for a garbage bin fine 2 years earlier. They invited me in and put on coffee, and for 45 minutes, I heard things I hadn't known. Karen had been crossing the corner of their rear property, as well as a strip along the back fence line, until they installed a low, ornamental flower bed border as a quiet deterrent. 3 weeks after the border went in, a fine notice arrived. $200. Reason? Installation of unlicensed garden structures within HOA setback zone without board approval. The flower bed was 14 inches wide and sat entirely within their private rear yard. They had paid it. They hadn't known they could challenge it. Mrs. Henderson told me she had cried when the notice came. Not because of the money, because she had thought briefly that the house was at risk. That was the mechanism, I thought. That was exactly the mechanism. Make the paper look official enough that the word lien becomes a distant but imaginable possibility, and a reasonable person will pay $200 to make it stop, rather than spend a month finding out it was never enforceable. The family across the cul-de-sac told a similar story, $350 in fines, across 2 years, grass length, and holiday decoration schedule and driveway stain. When the father attended an HOA meeting to formally dispute one of the fines, 2 additional violation notices appeared in his mailbox the following week. Different violations, same board president's signature. He had stopped pushing back after that. His wife had asked him to. The risk felt too open-ended. I told him I understood. I didn't tell him yet what I was planning. I thanked him for his time and moved on. The third conversation was the one I hadn't expected. His name was Dale. He lived closer to the street, and we had never talked for more than 2 minutes at a time. He opened the door, looking like a man who had been waiting for someone to knock. Before I had finished explaining why I was there, he said, "Hold on." He went inside and came back with his phone. He pulled up a folder in his dash cam app and handed it to me. The footage was from the camera mounted above his own driveway, pointed at the apron where his driveway extension met the street corner. 11 separate clips. I scrolled through them. Karen's white SUV, the plate clearly visible, cutting across the concrete apron of Dale's private driveway extension, on its way through the cul-de-sac. 8 months of footage. Clear date and timestamps on every clip. She had not been using one shortcut. She had been treating the entire cul-de-sac as a personal route, clipping private corners wherever they saved her 30 seconds. Adjusting as people installed barriers, moving to the next available edge. My lawn was just the current path of least resistance. Dale said he had never reported it because he didn't think anyone would listen. Margaret ran the board. The board ran the process. He had paid 2 fines already and didn't want more. I asked him the same question I had asked the Hendersons. Would he be willing to write a brief factual statement? Not a formal complaint, not a lawsuit. Just a written account of what he had personally witnessed, signed and dated. He said yes, without hesitating. I told the Hendersons the same thing before I left their house. Both said yes. The family across the cul-de-sac said maybe. They were still afraid of what another round of notices would cost them. I told them they didn't have to decide anything right now. That was true. I spent that evening assembling what I had, the certified plat survey, my own 23 incident photo log with timestamps, Dale's dash cam footage, 11 clips, 8 months, 2 signed neighbor statements, every fine notice Karen had sent me since month 2, the HOA bylaws with the relevant sections marked, the attorney's notes confirming no easement, no HOA authority over private lot access. Spread across the kitchen table, it was a substantial package. Not because any single piece of it was dramatic on its own. The plat map was just a plat map. The dash cam footage was just a driveway camera. But because together, they formed something that had a shape to it. A documented pattern, confirmed from multiple independent sources, all pointing in the same direction. I had not deployed any of it yet. The time wasn't right. I stood at the window and looked at the ruts in the corner of my lawn, pressed deep now darker than the surrounding grass, almost a permanent feature. I thought about the geometry of it, the exact angle she took coming out of her driveway, the precise width of the SUV, the 2 tire lines running parallel across the same strip of ground. 18 months of repetition compressed into a consistent 8-foot path. The plat map was on the table. The survey was in the sleeve. The folder was labeled and full. I started thinking about what else that ground could hold. The HOA meeting agenda arrived in my mailbox on a Wednesday. I read it standing at the end of the driveway. Most of it was routine, shared amenity maintenance update, parking reminder, vote on replacing the community mailbox cluster hardware. Then I got to item 4. Motion to formally recognize traditional vehicle access path across my address corner section as a community use easement, effective upon board approval. I read it twice. Then I folded the agenda carefully along its original crease, carried it inside, and set it on the kitchen table next to the folder. She wasn't going to stop driving across my lawn. She was going to make it legal retroactively, on paper, through a board vote she controlled without a court, without my consent, without a single recorded document at the county. She was going to stamp her own signature on my property rights and call it a resolution. I photographed the agenda and emailed it to my attorney before 9 that morning. He called back within the hour. An HOA board, he said, has no statutory authority to create, recognize, or record an easement on private residential property. A board vote produces a piece of paper. That piece of paper has no effect on what the county deed record says. She can pass the motion, he said. It won't mean anything legally, but she'll wave it around like it does. That was the point. She didn't need it to be legally enforceable. She needed it to look official enough that I would spend the next 6 months explaining to people why it wasn't. She needed it to feel settled. I asked him to draft a notice. The letter went out certified mail to each of the 5 board members individually, not to the HOA collectively, but to each person by name. It cited the state statute governing HOA authority. It explained why the proposed motion fell outside the board's legal powers. And it noted directly that board members who vote to pass a motion exceeding their authority may carry personal liability exposure if the affected property owner pursues the matter in court. Not a threat, a statement of law. There is a difference, and my attorney was careful about it. Within 48 hours, 2 of the 5 board members called my cell phone. Different voices, same message, almost word for word. They were not voting for the motion, but they would not say so publicly. They would not oppose Karen openly. One of them said quietly that they had seen what happened to people who did that. I thanked each of them for calling. I told them nothing further. Karen called me 2 days before the meeting. "You lawyered up," she said, over a corner of grass. A pause designed to let that sit. "Do you know what that tells me?" I waited. "It tells me you're scared." "No," I said. "I'm thorough." Another pause. Longer this time. "The board meets Thursday," she said. "You're welcome to attend." She ended the call. I set the phone down and sat with it for a moment. She had just told me without meaning to that she was still planning to push the vote through. She had received a certified letter from an attorney describing her motion as legally void, and she had decided to proceed anyway. That was useful information. It told me exactly how much time I had. That evening I opened my laptop and placed an order with a farm and garden supply retailer. 20 12-inch steel rebar landscape stakes, the kind sold commercially for raised garden bed borders and decorative lawn edging. Available in bulk, shipped standard. Nothing unusual about the purchase. I also added a bag of topsoil and a bag of grass seed. A landscaping project. Anyone who asked. The stakes arrived 2 days later in a plain cardboard box. Over 2 evenings, I installed them. I had studied the tire tracks long enough to know the exact path the SUV followed the entry angle from Karen's driveway, the diagonal line across the corner, the exit point where the tires returned to the road. Left tire track, right tire track, 8 feet apart at the widest point. I measured the standard wheelbase of her SUV model. I drove the stakes into the ground along both tire lines, spaced at intervals that would catch either wheel on a standard crossing. Each stake went in flush with the surface covered by the existing grass, invisible from the street. I photographed every stake as I placed it, framing each shot to include the county property line markers in the background. Date stamp on every frame. The documentation was as careful as everything else I had done, which is to say, thorough. Before I finished, I drove a separate stake at the entry point to the corner. Not rebar, but a 2-foot orange marker stake, clearly visible from the road. I attached a printed laminated card, private property, no vehicle access, small, unambiguous, photographed in place from 3 angles with timestamps. She had written notice from the certified mail I had sent 6 weeks earlier. She had posted notice now. She had both. I stood at the edge of the lawn and looked at the corner. The orange sign caught the last of the evening light. The grass looked exactly the way it had before the tire ruts, still visible from 18 months of crossings the surface, unbroken. Nothing different to the eye. Nothing that would register as a change from a car window. Everything was in place. Everything was documented. Every legal protection I could create for myself was standing. The HOA meeting was scheduled for Thursday. I didn't plan to stop her from pushing the vote through. I just needed her to keep driving across my lawn for 1 more week. The community room at the end of Birchdale Court held about 40 chairs. On the night of the HOA meeting, 31 of them were filled. I arrived early and took a seat in the back row, 3rd from the left. Folder on my knee closed. I didn't plan to open it. I was there to watch, not to perform. And there is a meaningful difference between those 2 things that Margaret had never seemed to understand about me. She ran the meeting from a lectern at the front. Clipboard, reading glasses, the laminated board president lanyard. She moved through the first 3 agenda items with the brisk efficiency of someone who has been running these meetings long enough to treat them as a formality. Mailbox hardware replacement approved. Parking reminder distributed. Shared amenity maintenance budget reviewed and tabled for next quarter. Then she clicked to a new slide. Item 4, she said. Motion to formally recognize traditional vehicle access path across the corner section of the property at, she read out my address, as a community use easement, effective upon board approval. The slide behind her showed a simple diagram. The cul-de-sac, the surrounding lots, and a dotted arrow running diagonally across the corner of one property. My property. The dotted arrow had a label, Traditional Pass-Through Route. She had made a presentation, with slides. I looked at the diagram for a moment. No survey, no plat, no county reference number, no recorded instrument of any kind. just a dotted arrow and a label she had typed herself. "This motion formalizes what has been a natural pass-through for this community for years," she said. She used that phrase twice in the next 3 minutes. Natural pass-through. The same phrase she had said to me in my own driveway on the morning this started. In the same tone, the tone of someone citing an authority that exists because they have said it often enough that no one has stopped them. She opened it to comment. A few neighbors spoke careful, neutral observations, the kind of language people use when they want to be on the record, without committing to a side. One man, 2 rows in front of me, said he thought the board should consult a property attorney before proceeding. Karen thanked him for his input and called the vote. Roll call. The first board member voted yes. The second voted no. He said it quietly and didn't elaborate. The third voted yes. The fourth voted no. She looked straight ahead when she said it. Karen looked at the room for exactly 1 second. Then she said, "Board president votes yes. Motion passes 3-2. I'll note that in the minutes." She wrote something on her clipboard. She did not look in my direction. Several people nearby turned to look at me. I made a small note in my folder. My expression, I was told later by Dale, did not change. The meeting closed 20 minutes later. I was still seated when most of the room filed out. I watched Karen speak briefly with 2 neighbors near the door, smiling, nodding. The particular ease of someone who has just gotten what they came for. Her husband was waiting near the exit. She put on her coat, said something to him I couldn't hear, and they walked out together. I followed at a normal pace. In the parking lot, they were ahead of me by about 10 feet. I was close enough to hear. Her husband. That shut him up. Karen, that's what the board is for. She didn't say it loudly. She didn't need to. She sounded finished. She sounded the way someone sounds when they have closed a door they expect to stay closed. I walked past them to my car and drove home without stopping. One of the 2 dissenting board members, the woman who had voted no, was waiting near the community room side entrance when I came back through the parking lot. She had her keys in her hand and looked like someone who had been standing there deciding whether to stay. "I'm sorry," she said when I got close enough. "I don't know what else I could do." "You don't have to do anything," I said. "This is handled." She looked at me for a moment, not quite understanding, not quite asking. Then she nodded once and walked to her car. I meant it literally. Everything that needed to be done had been done. The survey was in the sleeve. The folder was full. The orange sign was standing at the corner of my lawn, where it had been for 4 days, photographed and time-stamped. The ground along that tire line held 20 rebar stakes that had been in place for a week. The meeting minutes Karen had just recorded, the ones documenting a board vote that had no legal standing over a private deed, were now a piece of paper I could use to show exactly when and how she had been warned that this motion was void and had proceeded anyway. She had her vote. She had her slide deck and her dotted arrow and her 3-2 margin. I had the plat map, and I had the ground. 3 days passed. On the morning of the 3rd day, I was on my porch by 7:30 with a mug of coffee. The cul-de-sac was still and gray, the kind of quiet that only lasts until about 8 on a weekday. I had set my driveway camera to motion record the previous evening. I had not told anyone I was doing that. There was no reason to. At 7:48, the camera activated. Karen's white SUV backed out of her driveway across the street, paused, then turned the same angle it had been turning for 18 months, the same diagonal line toward the corner of my lawn, the same approach she had made 23 documented times before. She had her meeting minutes. She had her easement. She had 3 years of unquestioned habit telling her that corner was already hers. She had no idea what was in the ground along her tire line. She drove across my lawn for the last time at 7:48 on a Tuesday morning. She just didn't know that part yet. At 7:48, the camera activated. I was already on the porch. Karen's white SUV came out of her driveway on the same arc it had traveled 23 times before. Wide turn diagonal approached the corner of my lawn. The shortest distance between 2 points she had decided belonged to her. I watched it from the porch steps with both hands around a coffee mug that had gone cold 20 minutes ago. I did not move. I did not call out. I had been waiting for this exact moment for 3 weeks, and I had decided some time ago that I was going to watch it the way you watch something you already know the end of. The left front tire found the first stake at the entry point of the path. Not a blowout, a compression. A sudden resistance the tire wasn't expecting, the wheel dropping sideways into it, the whole front left corner of the SUV lurching downward and to the left, like something had grabbed it from beneath the grass. Karen braked hard. The right rear tire rolled over a second stake as the vehicle stopped. The SUV sat at a canted angle across my lawn, engine still running. 2 tires compromised the orange private property sign standing 2 feet to the driver's side window. She sat there for 4 seconds. I counted. Then she got out. She looked at the ground. She looked at the orange sign. She looked at the tire sitting wrong against the grass, and the stake barely visible at its edge. Her voice, when it came, was not the controlled boardroom register I had been listening to for 2 years. It was higher than that. You did this on purpose. She turned toward the house. You put something in the ground on my access path. She called my name twice sharp, the way you call for someone you expect to come running. I set the coffee mug on the porch railing and walked down the steps at the same pace I would have walked to check the mail. I'm going to call for documentation, I said. I went back inside. I picked up my phone and dialed the non-emergency police line. I said, "A vehicle has been driven onto my private property without authorization and has become disabled on the premises. I'd like an officer to come document the scene." Then I called my attorney on a second phone. He answered on the 3rd ring. I told him in 1 sentence what had happened. He said, "I'll stay on the line." I put both phones in my jacket pocket and went back outside. Karen was on her own phone by then, pacing along the edge of my lawn. Her husband had appeared in their driveway. I heard her say the word lawsuit twice. I stood near my porch steps and waited. Across the cul-de-sac, Dale was standing in his front doorway. The Hendersons were on their porch. The family across the street had one curtain pulled back. Nobody said anything yet. They were all watching. The officer arrived in 19 minutes. He pulled up slowly, took in the scene. Disabled SUV on the lawn, orange sign, 2 people standing on opposite sides of the situation, and got out without any particular urgency. Karen moved toward him immediately. She had the HOA meeting minutes in her hand. She had pulled them from somewhere, her bag, her jacket, and she was holding them, the way people hold documents they believe will end conversations. She explained the situation in about 90 seconds. The board had voted. The motion had passed 3-2. This was a formally recognized community use easement. The homeowner had put obstructions on an access path that the board had legally recognized. She wanted a report filed. The officer listened to all of it. Then he asked one question. "Ma'am, is there a recorded easement for this property at the county? Do you have a copy of the filing?" The meeting minutes stayed in her hand. She looked at them. "The board voted," she said. "That's the formal recognition." The officer looked at her, not unkindly, just evenly. "A board vote isn't a recorded easement. Is there a county filing a deed instrument? Anything recorded?" She didn't answer. I walked to my car, set my folder on the hood, and opened it. I didn't rush. I took out 5 items and laid them down one at a time. The certified county plat survey first. Property lines to coordinate my name in the owner field. Licensed surveyor's stamp in blue ink the recorded easement section. Blank because there was nothing to record. The officer picked it up and read the relevant section. He read it for about 15 seconds. Something shifted in the air of the cul-de-sac. I felt it before I saw it. The quality of the silence changed. Karen stopped moving. Her husband, who had walked across the street by then, put his hand on her arm once and let it fall. I put the original deed on the hood next to the survey. Then my certified mail confirmation, the letter I had sent Karen 6 weeks ago, postmarked and receipted, describing the trespass incidents by date and asking her to stop. The officer looked at the postmark. He looked at Karen. She was looking at the plat map. Then I put down the photo log. 23 incidents, printed each one, time-stamped each one, showing the tire tracks with the property line markers visible in the background. The last item was a printed photograph of the orange sign, taken 4 days ago, standing exactly where it was still standing, with the timestamp in the corner of the frame. The officer looked at the full spread on the hood of my car. Then he looked at Karen. "Ma'am," he said, "I don't see a recorded easement. I see a plat map with his name on it." That was the moment. Not a dramatic one. He didn't raise his voice. He wasn't performing for an audience. He was a county officer reading 2 documents side by side and stating what they said. But those 13 words took everything Karen had built on this corner, 3 years of unquestioned habit. The meeting minutes, the dotted arrow on the slide deck, the phrase, "natural pass-through," said with the confidence of someone who had never been asked for the paperwork, and reduced it to exactly what it had always been. A story she had told long enough that she had started to believe it herself. Karen's voice came back thinner than before. "The HOA owns this easement. The board voted. That's our authority." The officer. The board vote isn't a county filing. The plat says this is private property. My attorney's voice came from my jacket pocket, quiet but audible in the still morning air. Officer, for the record, an HOA board resolution has no legal authority to create an easement on private residential property. That requires a recorded court instrument or written consent of the property owner. Neither exists here. The board was notified of this in writing before the vote was cast. The officer nodded once. He didn't need it explained further. The plat was the plat. The deed was the deed. The meeting minutes were a piece of paper that didn't change what the county had on record. It was Dale who moved first. He crossed the street slowly, hands in his jacket pockets, manila envelope under one arm. He stopped next to the officer, not looking at Karen, and held out the envelope. "She did this to us too," he said quietly. "Those are every fine notice I've received in the past 2 years. I've got 11 clips on my dash cam of her vehicle on my driveway apron. 8 months of footage." He paused. "I've been waiting for someone to ask." The officer took the envelope. Karen's husband stepped toward her. "Margaret." His voice was low and careful. "Don't say anything else." For the first time in 2 years, she listened to him. The officer's summary took about 4 minutes. The vehicle had been driven onto posted private property. The owner had served written notice to the driver via certified mail prior to the incident. A visible private property sign had been in place at the access point for 4 days. The vehicle damage occurred during an unauthorized entry onto private land. This was a civil matter, not a criminal one. But the civil liability picture, he said, looking briefly at Karen and then back at his notepad, was clear. He would file a report. He recommended both parties consult their attorneys. Karen's SUV was towed from my lawn 40 minutes later. The tow truck came from the street side. The driver had to ask Karen to move her position so he could reach the vehicle. She moved. She didn't speak. As he was wrapping up the rig, the tow operator looked at me and said, "You want to press the trespass matter formally?" "Not today," I said. "I'll let the civil process sort it out." He nodded and pulled away. I stood at the edge of the lawn. The tire impressions from this morning were fresh over the older ones, 24 sets, now 18 months, compressed into one corner of ground. The orange sign was still standing. The plat map was back in its sleeve, back in the folder, back under my arm. I picked up my coffee mug from the porch railing where I had left it 43 minutes ago, still cold. I drank it anyway. Natural pass-through. She had set it in my driveway 2 years ago, like a legal designation, like a thing that had always been true. The county plat map had been sitting in a tube on my kitchen shelf the entire time, and it disagreed. It had always disagreed. It would have disagreed the very first morning she drove across my lawn, if she had ever thought to ask. She hadn't asked. That had been her only real mistake, and she had made it before any of this started. 2 weeks after the incident, my attorney called to tell me that Karen's attorney had been in touch. She was not seeking compensation for the vehicle damage. That avenue, her attorney had apparently concluded, was not one worth traveling. Not when his client had been served written notice 6 weeks before the incident, had driven past a posted private property sign at the access point, and had been doing so on land the county had never recorded any easement over. The call was about something else. Karen wanted to know whether I would agree not to pursue a formal trespass action or civil property damage claim in exchange for a mutual release. I told my attorney I was open to discussing it, with conditions. 3 conditions specifically. First, Karen would formally withdraw the easement motion in writing, not just walk away from it quietly, but file a written withdrawal with the HOA record, so that it could not resurface later under different language. Second, Karen would send a written notice to all 96 homeowners in the HOA, stating clearly that the so-called community access path had never been a legally recognized easement, and that the HOA board held no authority over private residential lot access beyond the scope of the existing bylaws. Third, every fine Karen had issued to me, the $150 fabricated citation, and any subsequent notices would be voided and refunded in full. My attorney passed the conditions along. Karen's attorney called back the following morning. He had advised her to accept all 3. She did in writing within the week. I read the signed document once, put it in the folder with everything else, and went to make coffee. The refund check arrived on a Thursday, $163.50, the $150 fine, plus a small amount of statutory interest that state law attached to improperly assessed HOA fines when they were formally disputed and refunded. I deposited it without making anything of it. It was not the point. It had never been about the money, but two other households made it about the money, and fairly so. The family across the cul-de-sac, the one where the father had stopped pushing back after retaliation notices appeared in his mailbox, called me about a week after Karen's written notice went out to the neighborhood. They had formally disputed their fines, using the same legal framework. Both refunded in full, $350 return. The father called to tell me. He said, "I didn't know it was that simple." I said, "It usually is once you read the document." He was quiet for a moment. Then, "Why didn't anyone tell us we could do that?" I didn't have a satisfying answer to that question. The honest one was that the fine machine worked precisely because nobody told you, and nobody told you because the people running it were counting on you not finding out. That was the whole mechanism. It had worked for 4 years. It had worked right up until the moment someone decided to read the document. As for my own surveyor and attorney costs, I kept those in my file and said nothing about them to anyone. They were the price of understanding exactly what I owned. I considered that a reasonable expense. Karen did not attend the next HOA meeting, or the one after that. The board, now operating without its most active member, retained an outside HOA legal counsel to review what had happened. The attorney's memo came back 2 weeks later. It confirmed in writing that the easement vote had been ultra vires, meaning the board had acted outside its actual authority and was therefore void. It had been void the night it passed. It would have been void even if nobody had challenged it. The county deed record had never changed. A board election was called to fill the open seats. 2 of the 3 members who had voted yes on Karen's motion chose not to put their names forward again. Karen nominated herself for an open seat. She received 14 votes out of 96 eligible homeowners. She did not win a seat. I thought about what she had said in the parking lot after the meeting, when she thought it was settled. That's what the board is for. She had been right in the end, just not the way she meant it. Dale won a seat. He called me that evening, sounding slightly stunned by the whole thing. "Any advice?" he asked. "Just read the bylaws," I said. "Every clause." He laughed. It was the first time I had heard anyone laugh about any part of this situation, and it was a better sound than I expected. The Hendersons replanted their flower bed border along the rear property line, the low ornamental edging Karen had fined them $200 for installing. They put in the same design as before, maybe slightly wider. No fine notice arrived, no board letter, no complaint of any kind. Mrs. Henderson waved at me from the garden the following Saturday morning. I waved back. That same Saturday, I went out to my lawn with a pair of pliers and a trowel. I pulled each rebar stake from the ground, one by one, wiped the dirt from the shaft, and dropped it into a cardboard box. 20 stakes, 20 small holes. I filled each one with topsoil and pressed it level. Then I scattered grass seed across the whole corner section, more than I probably needed, but the ruts from 18 months of tire crossings had compressed the soil, and the seed needed density to take. It would be a full season before the corner looked completely even again. I was patient. I had always been patient. I had a low decorative steel lawn edging installed along the full property line at the corner, black powder coat, 4 inches above grade, clean and straight and professionally set. Visible from the street, permanent, not aggressive, just a line that said clearly and without ambiguity where one thing ended and another began. The kind of line that should have been respected from the start. I rolled the certified plat map back up, slid it into its cardboard tube, and put it on the shelf above the desk, next to the deed. I did not expect to need to unroll it again. The information it contained had not changed. The property line had not moved. It had been exactly where it was the first morning Karen drove across it, and it was exactly where it was now. 6 weeks after the incident, I was on my porch with coffee. Same porch, same mug. Early morning, same quality of light as the day this started. The cul-de-sac quiet, the grass still holding the night's moisture. The corner of my lawn, edged clean and beginning to fill in where the ruts had been. Karen's white SUV backed out of her driveway, across the street. It paused at the end of her driveway. Then it turned right, the long way, the paved road, the legal route. The one that had always been there, that had always been the correct way, that took maybe 45 additional seconds, and required nothing from anyone else's property. She did not look at my lawn. She did not look at the porch. She drove. I took a sip of coffee and watched her go. Same porch, same mug, same white SUV leaving the same cul-de-sac. But the corner of my lawn was clean. The tire tracks were gone. The rebar was in a box in the garage, and the plat map was on the shelf where it belonged. Proof of something that had never needed to be argued. only shone. I never raised my voice. I never had to. The ground did it for me.